But as we were taking that, and as I'm standing in this ridiculous pose, the state police pulled up right behind the family member who was taking the photo, and then they immediately start trying to arrest me. Welcome back to the channel. Today is the day where I can finally talk about the legal side of crashing my Dodge Viper. For those of you who are new to the channel, I purchased my obtainable dream car, which is a 2004 Dodge Viper SRT10. I bought it back in 2019 and I paid about $35,000 for it, making it the cheapest one with a clean title in the country at that time. Then fast forward to earlier this year, I crashed it. So if you haven't seen them already, I'll link these in the description below, but I've already done videos on what happened, what caused the crash, all the damage estimates, and ultimately the fate of the vehicle. But in case you don't have the time to watch those, here's the quick synopsis. I was driving it to work very early in the season. It was a very cold morning, and I was actually going the speed limit, which is probably one of the only times I can say that about driving that car. But because it was a cold morning, I had very old and very cold summer tires. They lost traction when I was taking the highway exit without any warning whatsoever. The car spun around and it caught the exit sign sideways. Now the impact was relatively low speed. It was like 20-ish miles per hour max, and even though the total amount of damage was like half the value of what the car was worth, it still ultimately got totaled due to a lack of parts availability. Basically, Dodge doesn't make these parts anymore, and because they didn't make a ton of these things to begin with, there's no used parts and there are no aftermarket parts. So that was extremely frustrating, but what made it even more frustrating was that this caused me to get arrested for driving the speed limit. What? All right, let's take a quick step back here. I've done a number of videos about the ownership experience of this car, and in those I have said how this car gets you a lot of attention. And I mean a lot of attention, it is not always the correct type of attention. So even though the one that I personally bought was the cheapest one in the country and the paint condition was absolutely atrocious and it looked like garbage when I bought it, people don't necessarily see that. They don't see the work that you put into it to make it a good car. They just see what it is as a vehicle and then just kind of assume that you're some rich asshole. Now, as part of that, even before I purchased this car, I heard from other Viper owners and I found in the forums that this kind of, I would say, Viper syndrome exists in that you get stereotyped and then blamed for things even though you shouldn't really be at fault. And the example that I gave is how there was a Viper owner who was driving normally, somebody ran a red light and T-boned them, and they tried to say that the Viper was speeding and ran the red light and that's what caused the accident. But fortunately for that owner, somebody had a dash cam that was able to prove otherwise. But for whatever reason, just because of how this car looks, that is the type of scrutiny you get. So like I said, I found out some of that before I bought the car, but then I really realized the extent of it after I owned it for a while. But I didn't want to not buy my lifelong dream car for the maybe situation that this could potentially happen to me. But now, having gone through what I have gone through because of this crash, I would legitimately reconsider if you're going to buy one of these cars, because this is absolutely insane. This is the footage from the crash scene, and I went over this in the other video, but for anyone who hasn't watched it, I hit the post at a low speed. The car came to a full stop within about 20 feet or so. You can see the skid marks of where it came to the full stop that were in the dirt, and then I didn't realize that the front wheel was messed up. My first thought was, let's get it back to the road so the tow truck can get to it, and as a result of that, well, it's not exactly the best off-roader, so I left these nice long trenches as I tried to get back to the road, not realizing that the front wheel was locked from taking the hit. But that said, the dirt clearly showed that the farthest point of the car was stopped sideways, so it couldn't have possibly continued moving that direction within 25 to 30 feet. That was the farthest point away from the post, was 25 to 30 feet. So it was very clear that I was going a low speed. I obviously wasn't worried about anything really coming of this because I had a perfect driving history, and as I've said, I wasn't speeding. This was a low speed incident, and nobody else was at risk. Nobody else was around. Nobody saw this, but that's also something that you'll find out kind of did not really work to my favor because I didn't have anyone to say, hey, he was driving reasonably and just had a bit of bad luck. So with all this in mind, I think the evidence of what you can see of how the car actually stopped paints a very clear picture that this was not a high-speed incident. So the state trooper arrives, and I tell him up front, I said, I know how this looks. I'm a young guy. This is a sports car, but that's not what happened. This was low speed. You can see where the car stopped. You can see that this was me trying to get it back up to the road, and that front wheel is locked because it took the hit. You can literally follow the trail of where the car is now back to the post and see what happened. So in my mind, again, this is super obvious. I'll get an accident report, I'll file it with my insurance, no big deal. But of course that's not what happened, because the line of questioning that the trooper immediately hit me with was clearly to try to get me to confess to a crime, which again, I didn't commit. He's like, okay, well, how fast were you going? And I'm like, look, I'm not listing a speed. I wasn't speeding. It's like, all right, but if you were to list a speed, listen, man, I was not going fast. Yeah, but like, define not fast. How fast is that? So for those of you who haven't been in a scenario like this before, if you get pulled over for speeding, it doesn't matter if you say you were traveling 1 mile per hour over the speed limit. That is a confession that you were going over the legal posted speed limit, and they can give you a ticket on the spot. And because you confess to it, you're pretty much screwed if you try to fight it. And I know that because I have a clean record for the last 7 years, but when I first got my license, I was a little less smart. The other issue here is, even if I list a speed that was below the posted speed limit, this was on an exit ramp, like I said, and they have an orange sign, which is a recommended speed for the curve. If you haven't seen the full video of what happened, this exit goes between a 65 mile per hour zone and a 45 mile per hour zone. So the recommended speed is naturally, you guessed it, 25 miles per hour. So even if I said I was going 40 or 50 miles per hour, they would still write me a ticket saying I was going 15 or 25 miles an hour over the recommended speed, and I would have to either pay it or waste my time fighting it. That is a tactic that they love to use, at least around here. Fortunately, I saw that coming. I did not give him a speed, and I told him I'm not answering that. So once again, he has no confession. He's got no witnesses to say I was speeding. All the evidence points to, what happened, which is that I wasn't speeding. I think this is cut and dry. He goes to his car for a little bit. He comes back, and then he arrests me for reckless driving. If you're anything like me and you followed the evidence, crunched the numbers, ran the schematics, and I don't know, listened to basic logic, you're gonna probably think the same thing that I did at that time, which was, what the actual f***? Well, unbeknownst to me at the time, and despite them having no witnesses, no evidence to support that I was recklessly driving, and no confession, there were allegedly burnout marks farther up the exit ramp closer to where you first get off the highway. So this officer assumed, without any basis whatsoever, that I stopped and did 3 or 4 separate burnouts before crashing my car into a post. Again, while driving to work with my badge with my name on it. Which, if I did that, would make me the dumbest criminal of all time. So that was their whole case. They said, those are burnout marks, there's a crashed car, they can't possibly come from different vehicles, so you're under arrest. So now, this next part, I'm going to tell you right now, is going to sound a little bit ranty, but this should paint a very clear picture of how horrifyingly useless, biased, and unjust our legal system is. Reckless driving is not a traffic violation. It's not like a speeding ticket, it is a criminal offense. So here's how that is supposed to work. Number 1, you're accused of a crime and you're arrested. Number 2, they decide they're going through with this, they decide they want to prosecute you. Then both sides, both the prosecution and the defense, have to trade all of their evidence back and forth to actually discover what the truth is. That way they can get the big picture of what's going on and not, wrongly arrest somebody for burnout marks that were clearly from a different vehicle. Now, during this stage, you can also start discussing plea deals based on whatever evidence is presented, which basically means they want you to plead guilty, and in return, they'll either lessen the fine or lessen whatever the charges are. And then step 3, assuming that you haven't reached a plea deal or that they haven't decided to stop pursuing the charges, you go to some form of a trial. Now, on paper in the United States, they say you are innocent until proven guilty. In practice, that's not how they do it. For example, every time you get a notice of when you have to show up, it says notice of hearing, criminal. Bold letters at the top. And let's be real, just the fact that they're bringing this up before a judge carries with it the presumption that they have enough evidence together that you're actually worthy of prosecuting. So there is an implicit bias in doing that. So supposedly they're supposed to prove beyond any reasonable doubt that you committed this crime. In practice, you pretty much have to prove that you're innocent, even though that's exactly how this justice system is not supposed to work. You're supposed to have no obligation whatsoever to prove your innocence, and they have to prove your guilt. But let's be real, that is not how we practically function. And when it's your job on the line, and when it's your livelihood that could potentially be affected, said, whether you like it or not, you are now put in the uncomfortable position of proving your innocence, even though you should have no obligation whatsoever to do that because you were driving the speed limit going to work. So, how did this play out? Well, their whole argument was that these burnout marks had to come from my car because my car was crashed nearby. Pretty much the whole thing was predicated that the trooper saw burnout marks leading up to the scene of the accident and that he thought I was playing Tokyo Drift on my way to work. But here's the evidence that they were ignoring. That exit, specifically that exit, has one of the largest tourism attractions in the state, which gets a ton of traffic, as well as having two of the largest employers in the entire state. It is a very high traffic exit for that reason. Beyond that, they had no analysis whatsoever of the burnout marks. There wasn't anything to show that they were actually burnouts rather than somebody locking up their brakes on the exit. There was no analysis to show that those marks were similar to mine as far as darkness was concerned, to show that they were left around the same time. So there was no proof that they were actually left immediately preceding the crash. And then there wasn't any dimensional evidence either. So they didn't have any photos of it. In one of the videos I linked below, I initially said that I went back to the scene of the accident to go and get more evidence for the legal side. That is why. That's when I first found out that that was their evidence, and that's the first chance I had to go back to the scene to actually see, first of all, if they existed, and second of all, to prove that they weren't from my car. If they took photos of this, they could show the size of the tire, how far apart the tires were, and if the tread pattern matched up to my vehicle, because it got towed directly from the crash scene. So the next things we checked were the tread pattern. Like I said, it wasn't even remotely close to my car. The tires were about 4 inches more narrow than my tires were, and the spacing between the tires, which shows you how wide the car is, was a foot more narrow than how the spacing is on the Viper tires. Now, as I've said in many videos, the Viper is an extraordinarily wide car. It is ridiculously wide, so the tires are spaced more wide as a result of that. But the fact that the tires are 4 inches smaller and a full foot closer than what my tires are with a non-matching tread pattern should paint a pretty clear picture that they're not from my vehicle to anybody with 4 brain cells. But let's say that's not enough to convince you for some reason. Okay, let's look for physical evidence on the car itself. Like I said, it went straight to the body shop. I have several videos of walkarounds after the accident. There's no rubber chunks both up the side of the paint behind the rear tires, which would be indicative of a burnout. There's no rubber built up on the inside of the wheel well, which is where it would have built up if I was doing a burnout. There's no uneven wear on the tires from doing a burnout. There was no rubber smell, which you would have very clearly smelled if I was doing those deliberately. And there was also no smell of that burnt rubber at the scene of the accident. So at this point, it shouldn't even remotely be a question. So let's say for some reason that you decided to ignore 100% of that because you're trying to prosecute somebody because they have a Viper. Well, even if you looked at how dark the marks were and how quickly they faded over time, you could estimate that they were about 2 to 3 weeks old, whereas the lines that I left when the car was spinning were clearly more pronounced and dark. So they're the wrong time period, different tires, different spacing, wrong size, but other than that, I suppose they were both round. So now let's go to the logic side of this argument. Their logic was that while commuting to work, I stopped to light up a set of $2,000 tires in the middle of a highway exit during commuting hour. I would ask if that made sense to anybody, but I think that's pretty rhetorical. So at this point, their evidence was pretty clearly ruled out. So you think the state would reconsider this based on, the facts, the proven evidence, the video that shows the size of the tires and the spacing between them. But naturally, they don't, because instead they doubled down. Their argument was, well, those burnout marks might not be from you, but that doesn't prove that you weren't driving recklessly. And I said, well, that's your only indicator that you thought I was driving recklessly, so if you don't have those, you don't have reckless driving. So once more, their argument wasn't that they can prove I was doing it. Their argument was that I can't disprove it, which is just fundamentally flawed. That brings me to the next part of disproving this completely ridiculous scenario. You would think if they are arguing that despite the burnout marks, if I was still driving recklessly, that maybe they had done some sort of crash scene analysis to show that I was actually speeding leading up to the incident. And again, all of the marks within the dirt that could not have been faked clearly demonstrated that was not the case. But they didn't take any measurements, they didn't do any crash scene analysis, and they had no evaluations whatsoever to show the speed of vehicle both at the time of impact or before that when I was initially taking the exit and when the spin started. And to be clear, these crash scene evaluations are not something that's atypical. These are a fairly routine practice. They do it all the time for fatal accidents near me. But if they're trying to really press charges on something like this where there's another accident, that is almost always a case where they break out the investigators to recreate the crash scene. So even though the burden of proof is supposed to be on the state and they had done nothing to prove this, I took it upon myself to get done because once again, this is my livelihood that was going to get impacted. The analysis I had done said that I was traveling at a most likely speed of 62 miles per hour before the spin initiated with a possible range of 55 to 68 miles per hour. And that my estimated speed at the time of impact was 19 miles per hour with a possible range of 17 and 27 miles per hour, which, if you watch anything that I posted is dead on consistent with what I initially claimed. It's almost like I wasn't lying because I had literally nothing to gain from lying about it. So naturally, with this new piece of evidence, you would think the charges were dropped. No, that would be way too easy. And at this point, I concluded based on my own opinion, strictly, but also all of the evidence that they were just being dicks. So from their perspective, they see that I have a clean driving history and they don't want me to come out of this with a clean driving history because I crashed a vehicle. It doesn't matter that we have something to clearly attribute the crash to with the old and cold tires, and it also doesn't matter that this is the only time I have ever crashed a car in my entire driving history. For whatever reason, they decide they need something to stick on my record to show that this happened, which I think is absolutely absurd, and I don't want my rates to skyrocket because, let's be real, they're already going to hurt after crashing a Viper. So to me at this point, this whole thing seems like total BS. I was driving the speed limit as confirmed by scientific analysis. There's no other witnesses to say otherwise because, again, I wasn't putting anyone else at risk. I controlled the slide well enough to minimize the damage that did occur, but to them, it was still reckless driving. So to me, it's insane. It's beyond baseless, and I'm trying to get out of this with a clean record, and they're doing everything they can to make sure that doesn't happen. And if somehow I do make that happen, they're clearly at this point just trying to make it as painful as possible. Again, my opinion. So they're pushing for reckless driving, but at the very least, they want to hit me with the biggest speeding ticket that they can. Now here's the part that I will admit I made a mistake and I did something wrong. Now, like I said, this happened in the early summer time frame. It was a cold morning, but it was early summer, which means it's one of the first times of the season that the car was out of storage and on the road. Here in New Hampshire, there is an annual state inspection for safety and emissions equipment, and it expires on your birthday, which for me is over the winter when the car is in storage. Now, when I store my cars, I pull out the battery in the winter and it resets all the emission systems, so I have to drive them about 100 miles or so in order for them to actually pass inspection. But I had already done my spring tune-up. I had gone over everything mechanically. I'd done all the fluid changes. The car was in tip-top running shape. I can guarantee you it would have passed. But because I didn't run it through the state system and pay the money to the state, I was technically driving an uninspected car. And they are, let's say, less than lenient about it, even though this is clearly something that I'm not exactly driving to the mountains in the winter. So it doesn't matter that everything on the car met or exceeded the state's minimum requirements, and it doesn't matter that they don't even check for the age of the tires when doing the inspections because they aren't the ones who certified it safe. That is a minimum $60 ticket for having an uninspected vehicle, which in the grand scheme of things isn't that bad because the state inspection usually costs in like the $40 range. But the problem here is, per the letter of the law, I did not have it inspected within the time frame it was supposed to be done by because, of course, the car was in storage. So that means there was no way I could get out of this $60 ticket, giving them leverage. So basically what they were going to do was hit me with that inspection ticket, the $60 ticket, and then try to leverage every other fine they could possibly think of to try to get me to plead guilty and to try to run up the cost. That way I would have to plead guilty to something that put points on my record. That was their goal here. They just wanted to establish that I'm some terrible outlaw with a history of questionable behavior because I crashed into an exit sign at the speed limit. Here's where reality comes into play, right? I am a man of principles. I do not want to plead guilty to something that I didn't do, knowing that I didn't do it and knowing that I already have to pay the higher insurance premiums and the other consequences for it. But the reality is, It takes a lot of time and a lot of resources to fight these stupid things. The prosecutors know that. They know that you have to take time off of work every time you show up. They know that you have to respond to paperwork and that you have to file things accordingly to their deadlines. They know that there's an inconvenience of not knowing this outcome and having the results potentially loitering over your head, and there's a stress level associated with that. Whereas to them, this is just another day on the job. This is just a file in a folder somewhere. They really don't care that this is inconveniencing you. So despite the fact that 100% of the evidence, like I've shown today, points to the fact that I wasn't doing anything wrong, they had the leverage of the car being uninspected and knowing how much of an inconvenience that they could make this to try to get me to settle it and be done with it. Which I think is a garbage human being move, but that's what they do. So with all this in mind, here's what my two options were at the end of the day. Option one, I plead not guilty and stick to my principles. I go to trial and I try to fight this. I'm not a lawyer. I can't really afford a lawyer. The chances of me fighting this and me being successful, they're not exactly great. And furthermore, like I said, that's stressful. That's extremely stressful. And they were very clear about trying to add every single charge they could. For example, because my mirror shattered and flew off, littering. Because I hit an exit sign, destruction of public property. All these little stupid things added up to a little bit over $600 in fines. So best case scenario there, I win everything except for having an uninspected vehicle, which I really found no way to get around, and that is a $60 fine minimum. So I try to fight it, even if I get everything else thrown out, I have to pay $60 plus whatever the court fees are. Scenario 2 is I plead guilty to driving too fast for conditions, which is basically speeding with no actual speed assigned to it. On one hand, the fine is only $67, which is not bad, but it's the same 3 points on my license as if I was driving 25 miles an hour over the speed limit. But in return for pleading guilty, everything else goes away. There's no misdemeanor, there's no other fines, there's nothing for having the car uninspected. It sucks, my insurance goes up, it ruins my driving history, but everything else goes away and I no longer have to stress about it. Now, I am a man of principles. I tend to push things way too far out of principle, and I know that. I have been told I am the only person as stubborn as the husky they own. Even so, I like to take very calculated risks. I do not want to give myself any unnecessary exposure and open myself for an opportunity where I could either get really bad fines or have this arrest stick on my record. So the options are pay a $67 ticket for driving too fast, even though I was going the speed limit and we have all the evidence that says otherwise, and I have to give up on the principle of it, or I have a guaranteed minimum fine of $60 for not having the vehicle inspected, and the probability of it getting worse goes up substantially as they try to tack on everything else. When I was doing the math for the worst case scenario with all the fines and fees, it was $1,100 was the worst case scenario, and anyone who's been watching the channel for a while will know I don't have that kind of money just lying around. Even the Viper, getting the cheapest one at $35,000, even being my ultimate obtainable dream car, was a huge stretch goal when I first bought that. So to have fines ranging from $600 to $1,100 for something that, despite the evidence being pretty obvious that I wasn't doing anything egregious, just the risk level alone was too high to make it worth fighting that fight. And beyond that, I cannot risk anything impacting my real job for an arrest record. I cannot take that risk. That is what it comes down to. So if I ever have the option of 50-50 coin toss of whether or not you're convicted of a crime versus pleading guilty to a $67 speeding ticket, that's a no-brainer. I need to have food on my table a lot more than I need to not have speeding tickets on my record. That's the reality of the situation. So does it bother me that I had to do that? Absolutely. As a man of principle, that kills me that I had to do this, and I wish I had the time and resources to fight it, but the reality is I don't, and they know that. So given the same options, I don't think any rational person would do anything different. So for anyone watching, let's make this a learning lesson to help you not get into the same scenario. If you get pulled over, do not, under any circumstances, list a speed to the police officer who pulled you over. They're not your friend. Their job is to get convictions and give out tickets. Had I listed any speed at all, doesn't even matter if it was the real speed I was traveling, which was above the recommended speed but below the speed limit, things would have played out substantially worse for me. Any speed listed at all could have been counted as a confession in that scenario. Second, it's that our justice system is not about right or wrong, it's about win or lose. It's not about the facts, the data, the evidence, and the clear and obvious fact that I was putting nobody at risk despite being charged with reckless driving. It's about appealing to the ego of those who think they have power in a scenario, despite showing them conclusively with data, science, observations, data, math, and science that they're wrong. But anyhow, that is the story of how I got arrested for driving the speed limit in a 2004 Dodge Viper. I'm really glad to have all this behind me at this point, and I'm glad that this is over with. And for those of you who have been around the channel for a while, you've known that I've been saying I will not consider a Viper replacement until the legal side is resolved. And now we are there. So with that, thank you guys for watching, and I will see you next time.